Good afternoon, everybody, and happy holidays to all. Thank you all for being here today. My name is Robert Capers, and I'm the U.S. Attorney for the Eastern District of New York. Joining me at the podium today are Michael Harpster. He's a special agent in charge of the Criminal Division of the New York Field Office of the FBI, and Andrew Serezny, the Director of Enforcement for the Securities and Exchange Commission. Today, this office and the FBI are announcing the arrests this morning of Martin Shkreli and Evan Grable, and the unsealing of a 7-count indictment charging Shkreli with securities fraud conspiracy, securities fraud, and wire fraud conspiracy, and Grable with wire fraud conspiracy. Director Serezny will also announce the filing of a civil complaint against Shkreli and Grable by the SEC as part of their parallel proceeding. Now, the defendant, Shkreli, is charged in all 7 counts of our indictment for orchestrating 3 interrelated schemes, 2 involving 2 different hedge funds that he ran, that he founded and he managed, and the third involving Retrophin Incorporated, a publicly traded company that Shkreli founded and at one point controlled as its chief executive officer. The defendant, Evan Grable, a New York City-based lawyer and outside counsel to Retrophin, is charged with 1 count of wire fraud conspiracy for his role in the Retrophin scheme. Now, as alleged in the indictment, Shkreli essentially ran his companies like a Ponzi scheme, where he used each subsequent company to pay off defrauded investors from the prior company. So if we look to the board, to my right and to your left, Shkreli started out with a hedge fund in 2009 called MSMB Capital. And he took in approximately $3 million from 8 investors based upon lies that he told them about his prior performance as a portfolio manager, the amount of assets under the fund's management, and the oversight of the fund by independent auditors. But when he lost the $3 million that he'd gotten through a series of bad trades, he didn't tell his investors that he lost their money. Instead, Shkreli started a new hedge fund, which you'll see, called MSMB Healthcare, which he founded in 2011. And here again, he lied to the investors in the same way. He concealed from them the prior truth about his performance with MSMB Capital and the fact that he had lost $3 million based upon bad trades, the amount of money under the fund's management, and other things. Through those lies, the defendant, Shkreli, was able to get approximately $5 million additional dollars in investments from 13 investors for MSMB Healthcare, all while Shkreli continued to lie to MSMB Capital investors by telling them that their investments were performing well and that they were getting handsome returns on their investment. Now, here's where the Ponzi scheme similarities begin. Shkreli used money from MSMB Healthcare to pay off debts that he incurred from the series of bad trades that he made at MSMB Capital. Now, why did he do that? He did that to conceal the lies that he told to MSMB Capital investors, namely that their investments were doing well and they were getting handsome returns. Now, because the defendant, Shkreli, used that money from MSMB Healthcare to pay off those bad debts as part of the bad trades he made, he also used money from MSMB Healthcare to function as seed money for a company he founded called Retrophin, which you'll see to the right was founded in 2012. Now, so he lied to them. He lied to the investors in both of the funds about how the investments were doing, and in the instance of MSMB Healthcare, he lied to them about what he was actually doing with the money, all the while promising his investors that they were receiving exceptional returns. And then we get to Retrophin, the company that he took public. Shkreli invested some of the money from MSMB Healthcare's money into Retrophin, as I discussed before, as seed money, to get that company started. And as fate would have it, that company went public and did very well. But because Shkreli lied to MSMB Capital and MSMB Healthcare investors about the exceptional performance on their investments, he found himself at a crossroads. Either come clean and have to admit that he lied and he lost money and have all those lies discovered, or continue his lies and somehow pay the investors and somehow pay them the returns on their investments and the investments that they put in. And like Shkreli did in the past, he made the wrong choice. He lied. But this time, he did it on the back of Retrophin and used company counsel Evan Grable to deceive Retrophin's auditors and board of directors. Now, why did he do that? So that the two defendants, Shkreli and Grable, could use Retrophin as Shkreli's personal piggy bank to pay back the shareholders from both funds who had repeatedly at this point demanded their initial investments back and the returns on the investments that they were told that they had received. Now, how did he do that? He perpetrated the fraud in a number of ways. By backdating documents to create an investment that didn't exist. They then entered into settlement agreements with some of the defrauded invested hedge fund investors and paid them using Retrophin's assets that they hid from the board of directors and from outside auditors. Now, when auditors discovered these settlement agreements and told the defendants that they were essentially committing fraud, the two defendants came up with another way to steal money from Retrophin. They entered into what's called sham consulting agreements between Retrophin and the defrauded hedge fund investors, where the two defendants used Retrophin funds to pay the defrauded hedge fund investors in cash and stocks masked as consulting fees for work that was never performed. Now, as a result of this scheme, Retrophin, the publicly traded company, ended up paying out at least $11 million in cash and stock to make Shkreli's defrauded hedge fund investors whole. Now, these charges in today's indictment highlight the brazenness and the breadth of Shkreli's schemes and the outrageous web of lies and deceit weaved by both defendants, Shkreli and Grable. Shkreli, as Retrophin's chief executive officer, was entrusted with protecting both Retrophin and its shareholders' assets. And instead, he abused that power and used the public company's assets to pay off his own personal debts. And Grable, who was being paid by Retrophin to represent the company's interest, used his law license and his training as the cover so Shkreli could perpetrate his fraudulent goals. Now, by these arrests and the unsealing of this indictment, we hope that the message is clear to hedge fund managers, corporate executives, and attorneys who may be committing similar crimes or thinking about doing so. And if it's not clear, here's the message. The message is that we'll be tireless, this office, the FBI, our partners in the SEC, and our efforts to uncover your schemes. No matter how sophisticated, no matter how long it takes, we will bring you to justice. Now I'd like to thank our partners at the FBI for leading this investigation and the SEC for their continued partnership, close cooperation, and invaluable assistance. I'd also like to thank the AUSAs who worked this case, Winston Pays, Alexandra Smith to my right, David Kessler, and Brian Morris, criminal investigator Martin Sullivan, FBI Special Agents Christopher Delzato and Michael Bracconi for their tireless efforts which led to today's action. At this time, I'd like to introduce Michael Harpster from the FBI, and he'll provide you with additional details, after which Director Cerezny will address you. Thank you.
Thank you, sir. Good afternoon. These charges announced today describe a securities and wire fraud trifecta of lies, deceit, and greed. As charged, Martin Shkreli targeted investors and retained their business by making several misrepresentations and omissions about key facts of the funds that he managed. The hedge fund, however, was essentially worthless. At this point, Shkreli, along with outside counsel Evan Grable, conspired to create a series of settlement agreements detailing the payoff to MSNB Capital investors without the approval of Retrophin's board of directors. In the end, the settlement and the sham consulting agreements resulted in investors suffering a loss in excess of $11 million. While the charges announced today are significant, they are but one example of what's left to come as the FBI continues this investigation. Many thanks, as always, to our partners from the Eastern District of New York, U.S. Attorney Robert Capers, Chief of Business and Securities Fraud Section Winston Pays, and AUSA Alexander Smith. I'd also like to thank our partners at Securities and Exchange Commission, specifically Director of Enforcement Andrew Cerezny. And last but not least, I extend my sincere congratulations to FBI Special Agents Christopher Delzato and Michael Bracconi and Supervisory Special Agent Leland Perez for their work on this investigation. Now I'd like to introduce Director of Enforcement Andrew Seresmi.
Thank you very much. Earlier today, the SEC filed an enforcement action charging Martin Shkreli with fraud in nearly every aspect of hedge fund investing and in connection with his stewardship of a public company. We allege that this scheme had multiple victims. Over a 5-year period, Shkreli perpetrated a series of frauds on individuals and entities who had a business relationship with him, including investors who invested their money in a pair of hedge funds Shkreli controlled, a financial institution that served as an executing broker for Shkreli's hedge funds, and lastly, investors in Retrofin, a pharmaceutical company Shkreli founded and took public before he was ousted from it last year for his fraudulent acts. We have also charged Retrofin's former counsel, Evan Grable, with aiding and abetting Shkreli's fraud on the company. During this time, Grable also acted as corporate secretary for the company. Holding hedge fund managers and corporate executives accountable for their wrongful conduct is critical to the SEC's mission of protecting the investing public. Shkreli's repeated violations of the law demonstrate that he should be barred from working in the securities industry or being an officer or director of a public company. With today's actions, the federal law enforcement agencies present here have demonstrated that they intend to hold Shkreli accountable for his misconduct. Just a bit more on our action. Our complaint alleges that between 2009 and 2014, Shkreli repeatedly violated the anti-fraud provisions of the federal securities laws. In his first year operating his hedge fund, MSMB Capital, from November 2009 to November 2010, Shkreli spent, misappropriated, or lost through poor trading decisions all but $331 of the $660,000 or so of investor funds raised. In December 2010, Shkreli solicited additional investors to keep the hedge fund alive. We allege that when soliciting, Shkreli misled in particular one investor by giving the investor false information about the fund's assets under management, its prior performance, and whether the fund had an auditor or administrator, all important data points for someone considering investing in a hedge fund. As a result of this deceitful conduct, we allege that Shkreli raised more than $1 million from this investor. Altogether, Shkreli raised an additional $2.35 million for MSMB Capital in December 2010 and January 2011. However, by early February 2011, Shkreli had lost all of those funds through his unsuccessful trading. Specifically, on February 1st, 2011, Shkreli put on a massive short position in a security in MSMB Capital's account by lying to the hedge fund's executing broker about the fund's ability to cover the short position at settlement. MSMB Capital was not able to settle the trade, which forced the executing broker to cover the short position in the open market at a loss of $7 million. The broker brought an arbitration proceeding against Shkreli, which was eventually settled in 2012, and to fund this settlement, in early 2013, Shkreli stole $900,000 from another hedge fund, MSMB Healthcare, which he had founded in 2011. Although Shkreli had lost all of MSMB Capital's assets due to his poor trading and misappropriation, for over a year he repeatedly lied to funds investors, telling them that MSB Capital's investments were significantly profitable and that it had high positive returns. After losing all of MSMB's Capital's funds, Shkreli founded Retrofin, which in December 2012 became a publicly traded company. By this time, Shkreli had to contend with disgruntled hedge fund investors who were threatening legal action against Shkreli to recover their lost investments. In order to resolve these investor disputes, Shkreli, as he had done to settle the arbitration brought by the broker, once again turned to fraud. He fraudulently induced Retrofin to pay stock and cash to these disgruntled investors by disguising the payments as consulting fees. Shkreli had Retrofin's corporate secretary and attorney Grable draft sham consulting agreements, although Shkreli and Grable both knew that the agreement's true purpose was to settle claims against Shkreli and not to provide Retrofin with consulting services. In closing, I'd like to thank Rob Capers and Michael Harpster and their teams from the U.S. Attorney's Office and the FBI. Their work in this matter represents the best in professionalism, dedication, and public service. I thank them for the close collaboration and coordination with the SEC on this matter and on others. Lastly, I want to recognize the hard work and dedication of the SEC staff in the New York office, who conducted this investigation incredibly diligently. Their effort has been exceptional, and I'm proud of what they have accomplished. Those people are Andrew Calamari, Sanjay Wadhwa, Jerry Gross, Eric Schmidt, and Paul Gizzi. Thank you very much. I'll turn it back over.
Folks, questions? That's not a part of our investigation. I wouldn't want to speculate on his reasoning for trying to increase the price on those drugs. As you'll see from our indictment, 6 of the 7 charges charge him with conduct involving the 2 hedge funds that he started and that he blew the money in. And then the final charge deals with Retrophin. So, anybody else? Yes, sir. Well, I won't debate the merits of a defense in advance of trial. What I can tell you is that the money that he took from MSNB Healthcare and used as seed money for Retrophin, it was not disclosed, in essence, to the shareholders or to the investors that that's what the money was going to be used for. With hedge funds, it was presumed that the money was going to be invested in various stocks on the trading floor. Yes, ma'am. I won't comment on that at this point, ma'am. Well, again, we're getting into intricacies within the law. Are you talking about the privilege between the 2 defendants? Well, I won't get into the intricacies of that, but what I will note is that there's something called a crime fraud exception that would vitiate some privileges that might apply here. Yes, sir. Well, we won't get into questions of intent, but what we can say is it was a Ponzi-like scheme in as much as the funds that he raised for the first fund, MSNB Capital, were all expended through bad trades. And what he continued to do is he continued to lie to those investors and say actually that the fund was performing well and giving them handsome returns. At a certain point, when you continue to lie, it catches up with you, and as I discussed before, you face a crossroads. His crossroad was to continue using money from the other fund to keep people going. Yes, sir. I'm sorry, sir? Well, I won't comment specifically on what got us into it. I can say that this investigation did begin when he was the CEO of Retrophin. Man behind me. There were some arbitrations that were successfully resolved and others that were not. So there were investors who were left whole and some were not. Yes, ma'am. I'm glad I'm not the only one. I wondered how long it was going to take for that. I can't comment on that. As I said, this investigation centers on his conduct as manager of these funds. We're not aware of where he got the funds that he raised for the Wu-Tang Clan Act. The top count, the maximum sentence that he can face is 20 years. Of course, there are guideline ranges that we won't discuss at this point. So. Yes, ma'am. Yes, ma'am. I can't comment on that specifically, but as the indictment and the press release outlines, the 2 defendants working together with Mr. Grable working as outside counsel and receiving payment in the way of fees perpetrated the scheme that they did. I won't get into who knew and who knew what and et cetera at this point. Yes, ma'am. Well, the investigation is ongoing, as all investigations are, and we'll follow the evidence, and if it leads to more, it may. Yes, sir. Are you talking about in the criminal context? Okay, in the criminal context, we're following the investigation wherever it takes us. We won't comment what we're investigating and what avenues we're taking, but if you stay tuned and we continue with the investigations, and hopefully it'll bear fruit. Okay. Yes, ma'am. He is scheduled to be arraigned sometime later this afternoon across the street in the courthouse in front of Magistrate Robert Lee. Okay, folks. Oh, yes, sir. As I said before, as the investigation ensues and we follow other avenues of evidence, it may or may not lead to other arrests. Okay? Okay. Thank you very much, folks.